Hi, I'm attorney Jeff Greenberg, and I'm with the firm Howell, Buchan Strong. I've been practicing law for over 33 years and have a vast amount of experience in the healthcare area. Today, I'd like to talk to you about employment agreements for physicians. Many times, physicians who are either getting out of med school or switching practices will present me with a contract for review. There are many issues involved with reviewing this contract for the physician. The most important issues I find are relating to compensation, moving expenses, insurance, meaning malpractice insurance and tail insurance, which is something that you would need after you leave a practice, and the non-compete. Once a physician enters into an employment agreement, they're subject to that non-compete, and they want to limit that as much as possible in order to move on to a different practice or a different hospital after their employment is completed. Regarding the non-compete, that's a very critical aspect of the agreement. Now, non-competes are all measured by the time, the subject matter, and the area. If any one of those is deemed beyond the bounds of what Florida law allows, the non-compete will be null and void. However, usually I see non-competes in the employment contract context anywhere from 1 to 2 years in duration and within a certain mile radius of where you're going to be practicing, meaning 5 to 10 mile radius of the facility at which you're practicing. Thirdly, the subject matter is usually only relating to your practice area. They cannot prevent you from practicing medicine globally, anywhere in the state, for example. That would be void. So the physician's interest is in limiting the time and the area to something that they can live with because they need to make a living, obviously, after they leave the practice. Other issues with respect to the agreement include the compensation, obviously, how they get bonused, whether moving expenses are paid for, whether there are callback provisions that allow the employer to take back those moving expenses if certain goals are not met. Non-compete provisions can be very lengthy and should be reviewed by an attorney. However, things to be careful about include whether there's a buyout provision with regard to the non-compete, which means that you can pay to get out of the non-compete a certain dollar amount. You see that many times in the non-compete agreements. There's also other provisions in there that prevent you from working for affiliates or different types of businesses which you may have an interest in, even if you're not practicing medicine for those entities. So it's very complex, and you really need to seek legal counsel with respect to the non-compete.